Good afternoon, everyone. My name is Raheel Hyatt. Thank you for joining us. Welcome to CMCP and CEB's Bootcamp series on how to become an effective CLE speaker. As some of you might know, this program is part of a series of programs that CMCP and CEB has designed to teach attorneys who are interested in becoming CLE speakers on how to prepare and become effective speakers within this format. Our first program, which we hosted about 2 weeks ago, covered the themes of why one should be interested in teaching. And I thought that our speakers did a great job of highlighting not only why you should teach and how you can grow your brand by teaching, but also by teaching how you can become effective advocates for your clients. So if you have not had a chance to watch that program, I would highly encourage you to do so. Should be available on CMCP's platform and also on CEB's platform. And if you have any questions on how to access that, you can ask us. Today's program is going to talk about how one should actually prepare and then deliver their CLE training. So today's program, the speakers will go over how to plan a training around a substantive legal topic and then deliver it in an effective manner. So it's a really important training if you are interested in learning how to become a CLE speaker. So just a reminder that we will be playing the program first, and then we have a scheduled Q&A with the speakers. So if you have any questions for either of our speakers or for me or my colleagues who plan these programs on a day-to-day basis, then please feel free to stick around and forward us your questions. We'll be taking them through the chat feature after the program. With that, I'm going to go ahead and turn it over to my colleague, Connie, who is going to introduce our speakers for today, and then we'll jump right into the program. Thank you.
Thank you, Raheel. Good afternoon, everybody. My name is Connie Voss, and I work with Raheel. We are content attorneys at CEB. And it is my pleasure today to introduce two attorneys that I met a little bit ago and have been working with for some time on some wonderful continuing legal education programs, Zaccheo Norton and Somita Basu. They are partners and founders of Norton Basu, located in Santa Clara, California, in the Valley. And they practice in estate planning, conservatorships, probate, and trust administration. And I should let you in on a little note that at this time, we are working on some real property programs having to do with real property and trust. And as Raheel said, there will be a short Q&A after the program where we'll be able to hear more from the speakers. And I want to thank you again for joining us this afternoon, and please enjoy this wonderful program.
Welcome, everybody, to our presentation on the ABCs of advising clients on choosing the right successor trustee, including tips on how to give a stellar presentation. We would like to specifically welcome members of CMCP to this speaker series. I am Somita Basu.
I'm Zaccheo Norton.
And we are from the law firm of Norton Basu LLP, based in the Bay Area and with offices in Southern California. We focus on estate planning and probate. And today we're going to be talking about the steps to go through when you're preparing to give a presentation. We are, of course, going to be talking about successor trustees and what they do, as well as the ABCs, literally, of advising clients on what they should consider when choosing this person for this important role. And finally, we're going to give you some feedback on how to conclude a presentation and things to do when saying no or when following up. So you're scheduled to give a presentation. Maybe it's your first time, maybe you haven't done it very often, whether it's virtual or whether it's in person at some point, maybe those will restart. It's normal to be nervous, so we're going to walk you through some of the things that you might want to consider.
So the first thing, of course, that we've all had to master in these last few weeks is, technology. So understanding the logistics of what the presentation is going to entail, what kind of platform is it going to be on, making sure that you work through any of those glitches ahead of time is really important in terms of building your confidence before you begin the presentation. So make sure you understand how many slides, how is it, are you going to have control of the mouse? Is somebody else going to be clicking through for you? And then, of course, how long is the presentation supposed to be? That's probably one of the most important things to consider. I think most people try to put too much information into these presentations, and then you end up just kind of reading slides, and that doesn't really make for an engaging presentation. So remember to give yourself room to pause and take a breath, and add some anecdotes other than what you have on the presentation, and of course, keep it timely. All right, and so continuing on that, this is kind of a more granular breakdown of all of the things that you should consider when you're thinking about the logistics. Part of this has to do with just the setup in terms of, are you speaking by yourself? Is there going to be a panel? Is there somebody moderating? That will change the tone of the presentation that you're giving. It will change whether or not you need to be asking things in a question format, or are you telling people things, or are you going to be engaging with somebody else, or are you just going to be holding the floor the entire time? And that should inform how you devise your presentation. Think about your branding at all times throughout the presentation. Are there going to be templates? Are you expected to create your own? What is that going to look like? Again, make sure you leave room for breaks or question and answer. I think a lot of times when you leave the Q&A just to the end, you can miss some opportunities. So it can be helpful to maybe build some of that in. And then, of course, think about what kind of credit, what kind of paperwork, all of the kind of back-end processes that also need to happen for the presentation.
Yeah, and I think it's important to note that while all of these things seem really technical and, minute detailed, they all contribute to giving you a comfort level when you're presenting. If you know that, you've already handled all the logistical issues, it can give you can kind of settle into actually presenting the topic instead of worrying about these kinds of things. And of course, as we always do, it's always a good idea to check out the space ahead of time if you're actually doing it in an actual physical location. It's a physical meeting. We always check out the space ahead of time to get an idea of where it is, what's the parking, especially if it's a place we're not familiar with.
Mm-hmm. All right, and then know your audience, right? And so this, for us, when we're presenting, we always try to think about, who are we presenting to? What do we want them to get out of it? What is their background? Are you presenting to lawyers? Are you presenting to, a company? Because the type of material that you're going to cover is going to change depending on who your audience is and exactly what you want them to get out of it. As Samita said, think about the seating arrangements. Whether or not you want to be in a circle, whether or not you want to be more like a lecture format, think about what makes the most sense for you and, what kind of message you're delivering. And that goes along with the format. You need to be thinking about what's the best way to convey this information. And again, we have it on here multiple times, but it really is important to think about your branding. How is this going to help you achieve what you're trying to do for your firm, for your business? What do you need to include to make sure that there's a return on investment for you as well as the audience?
Okay, so step 3 is customizing your presentation, and Zakia touched on this a little bit before, but you want to customize the information that you're presenting for the people that you're presenting to. A one-size-fits-all approach almost never works. You want to make sure that the level at which you're presenting is appropriate. And you also want to make sure that the examples that you give, whether they're from your practice or things that you've heard that other attorneys have gone through, whatever is the examples that you're giving, first of all, they need to be relevant and understandable by your audience. So you don't want to get into probate codes or, specific sections of the civil code with a general audience. You want to make sure you keep it high level, but you also want to make it interesting. So it's the human element that's really interesting for the general public. And I think even for attorneys, I think attorneys really love to hear examples from your practice or things that you've seen in court or whatever it is that you're talking about. Those real life examples, the case studies, as we would say, are really what draws people in and makes it relatable. So you want to make sure you do that in a way that's relevant to your audience. You also want to see are you trying to kind of sell your practice or are you actually educating? And it's always better to take the approach of this is an educational presentation. If all you're doing is trying to get more clients for your practice, that doesn't add a lot of value to the audience. You might add value to your practice, but people aren't coming away with information. You want, as we've talked many times already about branding, it fits in with your branding. And you want to be known as an expert or a real authority in the area in which you are presenting. And in order to do that, you need to focus just on education and not selling yourself.
That's right. And being human, we can't stress that enough. I know you touched on it a little bit. It really makes a difference if you can show up either online or in person and remember to just be a person. Law school can beat that out of us. I understand that, but try to get back in touch with, what you were like beforehand and connect with people where they are. Even online, I know that can be a little bit more difficult, but try to keep in mind, right, the audience and connecting with them on things that are going to be relevant to their experience.
Yeah, I think if you're using Latin in any way, shape, or form, you've probably lost the plot. So that's a
yes.
pro tip. Okay. And then the very last thing, after you've done your presentation, you've prepared, you know all the technical things that you need to do and be prepared for, you know what you're going to say. It's really just to make sure you're prepared and, you're not logging into your Zoom a few minutes late or right at the start time. You're arriving early. If it's a physical presentation, you're arriving early. We would suggest as much as 30 minutes early to make sure, you have parking and you know where to find the room. Oftentimes you think you know where it is, but you really don't. Log in early, be aware of what you're wearing, even if it's a Zoom. Make sure you are looking professional. We can't tell you the number of times we've had Zooms with attorneys or other professionals who are not presenting very professionally. So your online presence is really your new professional face. And so it should be just as professional as it would be if you were in an office.
Right. And if somebody is not there to time you and kind of give you those cues about when you need to move on or how much time you have left, then make sure that you have some sort of mechanism yourself that you can sort of glance at to give yourself a check of, where you are. And if you need to sort of speed things up or slow things down, make sure that you have that. And as Nita said, make sure that you're giving yourself enough time for things to go wrong. Right? You don't want to be caught sort of flat-footed if there's traffic or if you can't find the room or any of those things. So give yourself enough time for those things to go wrong and for you to recover and still be ready to go when it's time to present. And the other thing that we're going to touch on is, if for some reason you can't do this presentation, what's the best way to decline this and still preserve that relationship. And I think as much advance notice as possible, the minute you can't do it, you should absolutely communicate that. And you should still remember to say that you are so appreciative that you were considered to, take on this opportunity, for them to keep you in mind for any future presentations. If it's something that you are interested in doing, but just had a schedule conflict. And if it's really not something that you're interested in doing, then you should make sure that you say so and give them something that you would be interested in doing so that you can kind of direct them and pivot into something that would make sense for you to present on. And of course, be kind at all times. Everyone is trying to figure this out. So just try to remember to give people some grace, even if you have to decline the presentation.
Yeah, and just to add to that, while maybe there's an opportunity that isn't right for your schedule or right for what you're comfortable in speaking about, you should always be looking for opportunities to speak, especially as minority attorneys. You want to make sure that your name is out in the legal community. We want to make sure that all the voices are heard and that we are also seen as a source of expertise. And so presentations are an excellent way to do that. Okay, so now you're prepared, you've done everything, you're ready to go. And so now it's the main event, and we're going to talk about successor trustees, what they are and some basics about them. It seems like it's easy, but it's not as easy as it first appears.
Right. So a successor trustee is the person who takes over the management of the assets in the trust, either because the original trustee has passed away or because they have become incapacitated. And that's one of the great things about having a trust, is that you have this built-in person who can step up and start managing your affairs for you should you become incapacitated, and have somebody in place to, protect your assets when the time comes. And their job is simply to carry out the wishes that you have in your trust. So who gets what? How do they get it? Where do they get it? That person is the one that's in charge of doing that. This person can be oftentimes a family member that somebody selects, but it doesn't have to be. It can be a professional fiduciary. It can be an attorney. It can be a friend. And in some instances, it can be a bank. There's lots of different opportunities that are available. And it really is about picking the person or institution that makes the most sense for you and for your family.
Okay, so what does the successor trustee do? As Zakia said, they manage the assets, but they make sure also that the trustor's wishes are carried out. And that's really the main job, is to make sure that when I set up my trust, if Zakia is my successor trustee, she's making sure that everything that I wanted for my family and my friends that I've laid out in my trust, that's the pathway that I've laid out, and that's what she's going to walk down. That's what she's trying to do to the best of her ability. The successor trustee is a fiduciary, so they do have to put the interest of the beneficiaries first and foremost. They always need to be acting in the best interest of the beneficiaries. And they do have to take care of things like taxes, debts, selling property if required. There are notifications that need to go out as per the probate code. And there's quite a bit of probate code for what a trustee can and can't do, and where and when they can be removed if they don't do their job. So those are all parts of the probate code. And so there is a myth in the general population that, if you have a trust, the probate code doesn't apply, but the probate code still applies, and there are legal requirements that the trustee has to fulfill.
That's right. And there's a list of all of the wonderful probate codes that are at play whenever a successor trustee is taking action. So as Samita said, it's really not something where most people are going to know these codes, backwards and forwards. So you're going to need to make sure that you are taking this responsibility seriously. And more than that, making sure that you're picking somebody, if picking somebody to be the successor trustee, that somebody is going to be able to actually seek out the advice and not sort of put their head in the sand, because there's a lot of requirements that have to be met.
Yeah, and under the probate code, chapter 4, that's where all the litigation comes in. Chapter 1 and chapter 4. So that's where the bulk of it comes in. So for your own, information, we would encourage you to go through and read those chapters and make sure you understand, if you know where things could go wrong, it can help advise you, for you to advise your clients on how to do it right. Not just the trustors when they're picking the successor trustees, but the successor trustees as well. So it's always good to know where things could go sideways. Okay, So now we're going to get into the ABCs, and it's literally the ABCs. It's a very good way to remember it. I guess this is law school hangover for those of you who have recently passed the bar. So this is about the ABCs of actually advising your clients and the things that you want to make sure your clients actually consider. It's not just as easy as picking your son or your daughter.
That's right. And so A is for availability. So you need to pick somebody who is first and foremost willing to take on this role. As we've already laid out in the previous slides, it's a pretty big undertaking. So it's got to be somebody who's willing to do it and willing to follow your wishes, somebody who's able to do it. So they're going to be able to take the time out of their day. They're financially literate. They're going to be able to contact the attorney and take all the steps necessary. And we say local-ish because we have, of course, worked with successor trustees that are out of the area. However, there are some instances where you have to physically walk into a bank as a successor trustee in order to get things done. So they either have to be local or the ability to, come out to take care of some of those things.
Yeah, and it also depends on the nature of the assets. So, and how comfortable the person is working remotely. If you're, if you're picking somebody who's maybe not as familiar or comfortable with technology or doing everything through DocuSign, and taking virtual tours of homes or whatever it is that needs to be done, then, you probably don't want to pick that person, that type of a person if they're not local, because they're going to need to be boots on the ground if they're not comfortable with technology, which you would be surprised there's quite a few people who are not.
Well, I think the shelter in place has showed us that.
Yeah. We've actually had clients who don't have emails, believe it or not. So, yes. It does still happen.
Yes. Carrier pigeons to the rescue. So yeah. B is for background. So as we say, it doesn't mean that, the person that you're being asked to be the same background as the trustor, but it does mean somebody who is mature, who is able to be proactive. Again, the amount of successor trustees who sort of bury their heads in the sand, and then by the time they come out, there's an entire mess to clean up is staggering. So you really want to pick somebody who is going to take this seriously from the get-go. And sort of be on their P's and Q's. You also have to pick somebody who is able to mediate competing interests between beneficiaries. They can get very insistent when there's a lot of money on the table, as we can all imagine. So somebody who's able to navigate that and, maybe calm down some tempers when things start to flare. And somebody who understands the nature of the assets that are within the trust. So if you have LLCs and rental properties, and you're picking somebody who has no understanding of what those things are, it's going to be very hard for them to move forward in that role. They're going to be in over their head. So make sure that you're picking somebody who understands those things as well.
Yeah, the other thing to note is the paperwork is not insignificant, and the legal requirements of notices that have to be sent and things that have to be given notice of, etc., are all pretty rigorous. It's not something that you can say, oh, I'm just going to do it in a couple of weeks when I get to it. It's like when it needs to be done, it needs to be done. There's a timeline. So if you have a person who you're really close to, but they're just not good with those kinds of things, then that's not a good fit for you. Even if that's your best friend or your son or your daughter or whoever it may be, you have to look at what the role requires. And so there is a little bit of taking emotion out of it and thinking about who can actually do the job. We have seen wonderful successor trustees, and we have seen terrible successor trustees. And unless somebody resigns, it's very hard to, without litigation, it's very hard to remove them. So you want to make sure you pick the person that has the right temperament and background for the job.
Mm-hmm. All right. C is for confidence. So this is really talking about confidence in the successor trustee's ability to carry out, your wishes. So even if this person doesn't agree with, some of the things that you've decided to do, they have to be willing to say, well, this is what they wanted. This is what's in the trust. This is what I'm going to do. So that's what we're talking about. Also somebody that you're confident will actually communicate with the beneficiaries, that will get in there. Sometimes when situations get sticky or complicated, they can't run away. They have to roll their sleeves up and get in there. And lastly, somebody who is not going to inflame any of these areas of conflict. It really doesn't help if you pick somebody that you know your beneficiaries have already had sort of a tumultuous relationship with, because believe me, it is only going to get exacerbated when that person is the gatekeeper between them and their loved one's possessions or sentimental items, and of course, money or property. So think through, that choice pretty carefully.
Yeah, we once had a case where there were co-trustees, and they fought over everything, including knickknacks in the house that had literally no either sentimental or monetary value, and they still fought over it. And so a lot of money was expended resolving those types of issues. And I don't think that's what the trustor would have wanted. And so you want to make sure that, bad blood between co-trustees is not present before they actually have to act as co-trustees, because that leads to a lot of delays and expenses.
Right. And that was a situation where it was the parent, the trustors knew that these two siblings did not get along. And I cannot stress how much you cannot expect people to come together just because you put them in a position where they have to work together after you're gone. If they didn't like each other before, they are not going to like each other now. And it's just going to, make everything worse. I think by the end of that case, there was maybe 7 attorneys that were involved because they couldn't agree on anything. So that's not the way to get your loved ones to, rekindle a relationship. It's not by appointing them as co-trustees. So that's something to think about when you're advising clients too. We ask all of those kinds of questions because we see how it turns out.
Yeah, especially if one of the siblings was a caretaker for the parent. It's a recipe for disaster that comes straight from our, experiences, case study 101 on successor trustees. The caretaker child is usually the one who is mourning or grieving the most, and also probably has quite a bit of resentment because they're the ones who have been caretaking and the siblings have not. And if you think that when you're not here, that these children will all get along, it's not going to happen. So you have to have a very honest conversation with your client. It's easy as attorneys to kind of not get into these issues and say, well, that's beyond what I'm supposed to do. But you're really doing your client a disservice if you don't advise them specifically about these kinds of issues.
All right, don't worry, there's help. So the successor trustee who has to do all of the things that we've talked about, and as you can see, it's a pretty extensive list of tasks that they have to accomplish, all while contemplating the probate code. It's necessary that they seek out help. There are some who will try to go it alone, and 9 times out of 10, that's really not going to produce an optimal outcome. They should be hiring a team of experts and advisors to help them through this entire process. That team should include an attorney who's, representing them and helping them carry out the wishes of the trust. And then you need to bring in, the tax experts, you need the CPA, you need a financial advisor about what to do with the inherited retirement accounts that are outside of the trust, what to do with the investment accounts within the trust. All of those things are decisions that rest with the successor trustees. So they need to make sure that they're getting good, competent advice, because as we referenced before, they are a fiduciary. So this can't just be, a decision they make, at the drop of a hat. It has to be something that a prudent person would do under those same set of circumstances. The good news is the successor trustee does get paid for their work, and it is work. And all of the professional fees for this, team of experts, all of that is paid from the trust. So there's really no reason to, avoid having a team that can help navigate this process and keep the successor trustee, clear of any potential liability.
Yeah, it's really important to note that we do tell our successor trustee clients, like, you really should take the fee, because the fee is more than earned. It's depending on the nature of the assets, it can be a very extensive job to be a successor trustee. We've had successor trustees who've had to deal with um, family issues and dynamics, as well as multi-million-dollar properties, IRA accounts that weren't, passed, inherited properly, designations weren't correct. Everything kind of fell to the successor trustee, who was also the executor, and there was a probate, there was a trust administration. It was a lot of effort, and we encouraged her to take the fee, and she did, because it was a lot of work on her part, on top of, her regular job and her regular life. So it's not an easy job in a lot of cases to be a successor trustee. So it's definitely advisable to take that fee.
All right, so these are some common questions that we get asked. The first is almost every time is, they don't want to upset their children. Should they appoint both of their children as successor co-trustees? By and large, our advice is to avoid co-trustees for a couple of reasons. The first of which is that it's hard enough to get one person to move through this laundry list of things that have to happen. And now you've got to get two people to coordinate schedules logistically, right, to do all of these things. The second is that ties into that is now you've got two people who need to agree on everything, sign off on everything. And I think you can see we've all done group work before in the past, and we all know how that turns out. So it's definitely something that if it can be avoided, we would suggest that it is avoided. It's important for then those clients to have a conversation with their children, and we are happy to have those conversations too, and we do. And we say, here's the reasons why this is not a good idea. Here's what you're setting your children up for. It just sort of is a breeding ground for there to be resentment and conflict between the siblings. So it's something that we say to avoid unless it's absolutely necessary.
Yeah. The next one that clients ask quite a bit is, I really don't know anybody at all, so can you guys be my successor trustee? And this is for our estate planning clients. From our perspective, we decline every time there is an inherent, we think, conflict of interest if we serve as the successor trustee. So unless it's a personal, unless it's a family member or something like that, we do not provide this service to our clients. You want to be careful. Successor trustees have a lot of power, including during your lifetime. If you are incapacitated, how well do you really know your attorney? Are you friends with them? Have you known them for a long time? Or, are you going on somebody else's recommendation? How close are you to them? From an attorney's perspective, this area is rife for kind of overstepping your ethical guide boundaries here. And so our practical advice is, regardless of what may or may not be required under, professional ethical guidelines, we would recommend on a practical basis that you don't do this.
That's right. And the next thing that people want to know is, I'm naming this person as successor trustee, but they're not a beneficiary. They're not getting anything from my estate. What should I tell them? What do I do? And this is a situation where, your trust is a private document, so you certainly don't have to share anything with anyone that's named within your document. It can be prudent to actually talk to people that you're naming. One of those people, successor trustee, that's a pretty big undertaking. So our advice wouldn't ever be, no, don't tell this person that you've named them in this very important role in case something happens to you. What we do say is what we've discussed, which is, they will get a fee, and it's not a nominal fee. It's a significant fee, but it's, I think, in line with the amount of work that it is actually required from somebody in this role. And so I think that's the easiest approach, is to say, I would love for you to serve in this role. You are going to be paid. It's within the trust document. And that typically is enough for people to understand and appreciate they don't necessarily need to be a beneficiary in order to, do this work because they are getting paid.
Right. And, for guideline, it's anywhere between 1 to 1.5%. If it's a, individual, some of the banks charge significantly more. And by that, I mean double at least. So you want to be careful when you're naming a bank. You want to understand what the fee structure is. They also have requirements that may not work for you, for your family, in terms of which trust they will handle and where the trust must be located. The situs of the trust isn't necessarily always California, so be careful on that. But the successor trustee does get paid, and it's usually about 1%. That's considered normal and reasonable in California.
Right. And then the last consideration is, of course, well, what if this person who I've named, who I thought was so great, does something wrong? They abscond with money, they, whatever the case may be, what happens then? So the answer there is that, they are held liable. So the trust should always be drafted in a way that allows the beneficiaries to take the successor trustee to court and to remove them if they're doing something that they're not supposed to. You should always have a provision that allows them to remove that person for somebody else or put a corporate, trustee in the role. And aside from that, you can always take them to court for violating their duties. They have duties of loyalty, duties against self-dealing, all of those things. And I say those two because that's usually what has occurred. It's one of those two duties has been violated. And you can take them to court and you can surcharge them. And that means you can get back whatever money, they took or that's owed to the trust. So there's always an option to make sure that they're doing the right thing and to hold them accountable if it appears that they aren't.
Yeah, that's really where the bulk of this litigation lies as trustees. It's trustees gone wild. And so you want to make sure, that you understand what the penalties are, what the recourses are. If you have an older client, it's very possible that you might be also not just setting up the estate plan and advising on who should be the successor trustee, but also doing the trust administration. So it's important for you to be aware of what happens afterwards, if that's an area that you also do. So you want to make sure you know what those remedies are for you. And back to that probate code, chapters 1 and 4, which I said, always a good idea to take another look at that. And, in today's day and age, you don't need a book. You can just go online. Everything is there. So no dusty books in the office. Okay, so you gave a stellar presentation. You provided all the information that your audience was looking for. How do you actually wrap this up and exit gracefully?
So one of the very first things you should do is, of course, thank the host, thank the audience for taking the time to show up, and listen to the valuable information that you had to share. Definitely answer any questions that the audience might have. But while you're answering those questions, make sure not to get bogged down. Some people take that opportunity to ask very personal questions about their third cousin's niece's sister's boyfriend and what's happening there. And that's a good opportunity to say, let's take this offline. If they start getting really technical, because then, you're kind of on the spot. You don't have enough information to answer that question appropriately. And it's really not what the Q&A should be used for. So don't be afraid to say, that's a really great question. Here's my card. Let's discuss this offline. Because also they're sort of tiptoeing into an area where they should be paying for your expertise if it's that complicated for you to answer. So, make sure that you do that and feel comfortable doing that. Absolutely. Definitely always provide your contact information so that people can reach you for any follow-up questions they might have or to set appointments. And if it's relevant, have handouts for them. Some people want, the paper to take away with them if they want to write notes on it or just kind of have something from the presentation. You can always have, I think it goes 50-50 for us. People, sometimes they want the hard copy. Sometimes they'll just say, can you email me a copy of the presentation, which is great because then you've also captured their email, which you can use for other things down the road to share information with them.
Yeah, and if at all possible, try and save the handouts for the end, because what ends up happening is if you give the handouts ahead of time, everybody's looking at the handouts and people aren't looking at you or the screen or whatever it is that they're supposed to be looking at. So you want to make sure the attention is on you during the presentation, and not everybody, just looking at, the paper that you gave them. So we would encourage you to give handouts later if you can, if that's possible in the structure that you've got. The other thing I would say is, I don't know if you all have noticed, but our slides are bullet pointed. There's not a lot of dense text on there. We've included visuals where we can. They're simple, they're not overly complex, but they do give a break from even just bulleted lists of text. So you want to make your presentations be visually appealing. If that means you have to outsource, maybe you're doing the content, but somebody else is actually making it look nice for you and getting the right images. There are people who can do that. They can do it relatively at a low cost. If that's an option for you, you should look at that. That's a service that a lot of people can do, because you honestly should be focused on all the preparation things that we talked about and the actual content. If you have a hard time making all the fonts the same, or the bullet points don't look right, or you don't know where to get, visuals from, that's not necessarily your core competency. So you can outsource that, and you should. But then again, at the end of the day, you'll have a very nice handout as well that you can repurpose when and where you need.
Mm-hmm. And once you put in all the work into getting a presentation ready and got your branding is on there, you've made it look nice and clean, that's a model that you can use for any other presentation that you have to do, right? You can just take that and adapt it and tweak it to meet whatever, the subject is that you're going to be speaking about. So it really does pay off to, get all of that done ahead of time and have it set, so that, as Samita said, you're focused on the things that you need to be focused on for the presentation. And going forward, you've just taken that off of your list of things that you'd have to do in order to get ready for the next presentation and the next presentation. So.
Yeah, we have examples in some presentations that we do that we just change depending on the audience. So we have one where, if we feel like they're hip enough, then we would do a reference to Chandler and Monica Bing, when we talk about estate planning and changing titles. Sometimes it's Beyonce and Sean Carter, depending on the audience and, their age and their, affinity for certain pop culture references. We keep those, we change those for different audiences, and that's something that you should consider as well. Use a reference that everybody knows. It doesn't have to be a court case every single time.
Right. And that's a callback to being human. Whenever you can interject your personality or some humor into, these kinds of presentations about, serious topics, I say do it. I think it helps break up what's happening, and it helps get the audience kind of on your side and engaged into, what you're talking about.
Yeah. Okay. And I think at this stage, we are done presenting on successor trustees and also how to present on successor trustees. We are Norton Basu. Our contact information is here. If you want to contact us for any tips or any advice, we're always willing to help out our fellow colleagues. So please do contact us if you have any questions at all. Thank you.
Thank you.
Great. That was a great training. Thank you, both Samita and Sophia, for doing that. We are going to open the panel for Q&A, but before we begin taking questions from the audience, I just wanted to highlight 2 points that I thought both of you made in your training that were excellent. One, Samita, I believe you mentioned that when you're taking questions from the audience, I think it's important for the speaker to realize that you don't have to answer every question that is posed to you. Oftentimes when you're in a position to teach a CLE, you think that you have to answer every question and that you're the person of authority for that subject matter. But if you don't know something, it's okay to say, I don't know the answer to this, and do your research and get back to the person who's inquiring about that information. So I think it's really important to highlight that, because oftentimes I think the fear of the unknown is what prevents us from doing public speaking engagements. And it's okay to understand that you don't need to know everything, that it's okay to say, I can get back to you with an answer. So I thought that was a really important point. And then the second point I wanted to make was the way the two of you actually spoke to the audience, even though it wasn't a live program, I thought was great. It's something that hopefully our audience can take away from. So I thought both of you did an excellent job of that, engaging the audience. And I know it's tricky when you don't have a live audience in front of you to stay engaged. So we appreciate that. So with that, I'm going to go ahead and open up the questions. Again, if you do have a question, please post it in the chat box, and then Connie and I will go ahead and read them. And then Connie, I'm going to turn to you for the first question. So we'll go from there.
Thank you. Thank you for the presentation. This is about the fourth time that I watched this, and I know I'm going to keep watching it. Okay, so as I was listening to you, when you were talking about when you decline a speaking invitation, and it occurred to me that it is really important for when you decline an invitation to, as you said, keep your known areas of interest out there, so that when those areas do come up, I can keep you in mind, or the person that invited you can keep you in mind, or if I hear of somebody that is looking for a speaker in that area, I can definitely recommend you because I know what your area of interest are. So thank you for that reminder, because I often do recommend speakers when they don't speak for CEB perhaps, but I know of someone who is looking for a speaker on a topic. So I just wanted to jump back to kind of the whole notion of getting into a practice for yourself. And I was wondering if you might have any tips for people who are looking to go into solo practice. I mean, both of you have a very successful and growing practice at that, and wondering what you might offer for people who are thinking about going solo and starting their own firm.
I'll defer to you, Sumita, since you're the vice chair of that section for CLA.
I think the first thing you have to do is ask yourself, what's your risk tolerance? What's your, how much anxiety are you able to live with and handle? Are you the sole bread earner? Do you have enough savings? Ask the most practical questions first. Because if you don't have an ability to handle kind of ups and downs in revenue, if you don't have, enough savings, if you're not business minded, if you hate that part of practicing law, then being a solo small firm practitioner is not for you. You're not just an attorney, you're also a CEO, a COO, a CFO, the marketing person, the HR person, you're everything. And if those parts of running a firm don't appeal to you at all, I'm not a numbers person, I don't like the numbers, I don't like accounting, then solo small firm practice is not for you. So that's the hard truth of the threshold you need to cross in order to be able to enter solo and small firm practice. If you feel that you are able to do all those things, then you should think about what practice is something that you would want to be doing for many years going forward. I mean, do you like family law? Do you want to deal with that all the time? Do you like probate and estate planning? Is it business? Is it bankruptcy? What is it that would give you some satisfaction on the underlying area of law, aside from just the revenue predictions or forecasts? So those are some of the basic things that I would say people need to consider before going out on their own.
Yeah, and you know what? I would add that you have to be really, really comfortable and excited to network. That's a big thing that a lot of people don't like or aren't comfortable with, right? You have to meet new people, you have to come up with small talk, and you have to try to engage them so that you have some sort of relationship for your business to grow. And so if that makes you want to, dive under a table and never come out again, then it's probably not something that's going to work very well for you, because in the very, very beginning, I mean, that's what you're doing, right? You're out there and you're kissing all the frogs, and you're building, your network out. And so you have to be able to kind of go through that process, understand what it is. And it's something that never stops, quite honestly. We can't ever look away from networking. The minute you do, you notice it immediately in your business. And so that's something that you always have to be doing and have to be comfortable, doing on an everyday basis.
Right. Yeah, excellent point. So that kind of made me think of something that you mentioned, Sumita. So I'm curious what kind of experts or resources you follow in your area of trust and estates, just as you were starting, and then also just to keep up on a day-to-day basis.
We use a lot of CEB materials. Obviously, the practice guides are really practical and wonderful, and also available to everybody at no cost at the local county law library usually. So that's a really good resource. Every bar association has trainings and CLEs, the relevant section of the CLA or of your local county bar association will all have things. It's really helpful also to have know somebody who's been practicing in that area for some time, who can actually answer some of the nitty-gritty questions for you.
All right, thank you.
Great. We appreciate that shout out to CEB, Sumita.
I'm going to
always
let you have a chance to ask a question or two.
Yeah. So I think Arzu has a question. Arzu, did you want to go ahead and take that question?
Yes, and thank you so much for that great presentation. And I, like Raheel said, a couple of things, especially the bullet point at the end, really struck, stayed with me. Firstly, I just wanted to make a couple of points about those last points. I've been to presentations where the speakers are asked if they would like to take questions as they give the presentation, or if they would like to have it at the end. I think your preference would be to take the questions at the end, because I've seen that be a big interruption during the presentation.
Yeah, I think typically it's best, especially when you're first starting to do presenting. I think it's absolutely, you should say that you want to just take questions at the end, because like we said, people tend to ask questions that will kind of take you way off topic and veer into something really personal. And then it can be kind of hard to find your footing and get back into the rhythm and the flow of what your presentation is. So I think as a rule, we definitely lead that way. Sometimes every now and again, you may have some people that ask the questions, and that's fine as long as they're on topic. But what I will say is, if somebody does ask that question, because you can say you want questions at the end and somebody may still just shoot their hand in the air or just say the question. If it's relevant to what you're speaking about, feel free to answer it. If not, either say that's something you're going to be covering later or something that you can revisit when you're done with your presentation, and absolutely feel okay to do that, so that you're not then kind of scrambling to get back, on course for your presentation.
Right. And Sumita, do you have something to add to that, or?
No, I totally agree. I think it's always good to take it at the end, especially in the beginning. It also depends on in the crowd, how much knowledge they have on what you're doing, how big is the group you're presenting to, all those come in as factors. So we do take questions sometimes as we go through, but it depends on the situation.
Right, thank you so much. And I also like that you said the handouts should be kept until the end. I have been to a lot of presentations where they give me handouts with like blank PowerPoints, and they ask me to take notes as I'm listening. And like you said, it's difficult to focus on the speakers and their presentation and then take notes at the same time and try to fill in the blank. So I like that point very much as well. And I also have a question that I put in the chat. When deciding to teach the CLE courses, how do you decide which topic and which format? Because I've seen people who are experts in one field to be asked to do presentations in other fields, for example. Would you take that up if it has some similarities to the practice area that you're practicing in, or do you just stick to exactly what you're practicing?
I would say that I think it makes the most sense to stick to what you're practicing, just because if you're presenting about other things, people are going to start coming to you with questions about that. And if that's not really the area that you're trying to drive your practice in, then it's really not going to be helpful to you, because now you're spending more time on something that isn't what your practice area is. So I think For us, I mean, we stick to estate planning and everything under that umbrella. And, you know, recently now talking about presenting, because we've done that enough now too, that, you know, that makes sense to do. And we're happy to, you know, help people sort of, you know, gain confidence in presenting and get out there and, you know, help educate everybody, because I think that's always a good thing to do just in general and for your practice. But I would say just from a purely, I think, comfort and just business development standpoint, it makes the most sense to always be trying to engage with, you know, what your practice area actually is.
Right. I think it's kind of like what some of the lawyers do, solo and small firm lawyers. I actually worked for a lawyer long ago when I first started, and he had a door policy. So he would just take anything that came through the door because he was just starting and he didn't have much business. So I think it's kind of the same thing, that you have to just, you know your area. And how do you go about choosing the topic? How do you decide on a topic and format? I know you talked about the format of the PowerPoint, and that was something else that I really liked, to make it visually, I think you said visually appealing, and I think that's really important too, not to make it too dense. And I think you have a format that you might have a template that you use. So that was a really good point as well. So how would you decide on a topic? Oh, I'm sorry.
Oh, how do you decide on a topic? I mean, I think it's best to, there's two categories, right? So it's either something that's evergreen, like picking a successor trustee, which is pretty much the same, even if you play it 5 years from now. So it's like an evergreen topic, or you could do something that's much more topical. That's a development in your practice area, which would maybe get some new people there to see your presentation. So those are the two things that I would consider.
Thank you so much.
Yeah, I just wanted to highlight something that I believe Zakia and Arzu, you both mentioned before. So one, with the question, I think also the thing to consider if you are a speaker is whether you are presenting individually or on a panel. If you're presenting on a panel, oftentimes we encourage people on the panel to actually discuss the format of the program beforehand. So there's some sort of a loose script, especially if you're presenting it live, so that you're not talking over the other speaker, and that there's a set format there. And so in those circumstances, I personally would highly recommend that you ask the audience to wait until the end to pose their questions, so that you can get through the program first, and you know, the questions don't mess up the flow of your program if you're on a panel. So I just wanted to highlight that. And then the other thing I wanted to ask, we received this question, is how long did it take for both of you to feel comfortable in your practice area and consider yourself an expert before you started to do speaking engagements?
I think we have different answers for that.
Good.
I know I come from a management consulting background. I've had several careers before I became an attorney. And one of the things that I learned along the way was, you know, kind of fake it till you make it. So the thing to always keep in mind, my philosophy is, if you're the only attorney in the room, you're going to know more than, you know, everybody else that's listening. You know, do as much research as you can. Anything that's too complex for you that you don't know off the top of your head, you could say, we need to take that question offline. It's too complex for this forum. So you don't say, I don't know, but you just push it to another time, and then just start. Just start as soon as you can, because it builds confidence, it builds your brand, it builds awareness in the community about what you have to offer. So I think it's important to do it as soon as you're ready, or, you know, until somebody pushes you to do it, which is, I think, a little bit what happened with us.
As soon as you're ready, or as soon as your partner starts dragging you to the presentations that she's agreed that you guys are going to do. And so that, Savita definitely had much more comfort early on than I did. You know, I'm somebody that needs to be beyond overprepared in order to feel comfortable doing something. And she just kept saying the same thing to me, which is, you know, we already know more than everyone else in the room, just with what we've been doing, right? And what we've been preparing. So just try to keep that in mind. And I do think, especially as you're starting out, that phrase of, you know, that's a great question, let's take that offline. That's your best friend for something that comes up and you don't know the answer to. That's okay. It's going to happen. Just use that phrase, go look it up later. And the next time someone asks you that question, you're going to have that answer, or you're going to know if that question is even appropriate for you to answer one way or another. So I think Samita has it exactly right. I mean, the first few times you do it, you're not going to feel ready at all. And so you just need to jump off the cliff and get out there and do it.
Thank you. That's so true. It's like riding a bike, right? The more you sort of practice, the better you get. And then the other thing I think both of you have mentioned, and Arzu even mentioned briefly, was you don't necessarily have to reinvent the wheel every time you present. Once you become an expert on a topic, one, you'll notice that people will reach out to you to ask you to present on that topic, and two, you can always just update, your presentation or tweak it a little bit, but you don't have to essentially start from scratch every time someone asks you to present on the topic. So those are things to keep in mind. And obviously, the more you do a presentation, the more comfortable you get. So perhaps when you're first starting out teaching CLEs, you might want to focus on just teaching one or two topics that you're comfortable with. But as you start to explore and do more of these trainings and you get more comfortable, you probably want to expand and try to cover some more topics maybe that you didn't want to initially deal with. So yeah, those are all great points. So I'm going to go to Connie. Connie, do you have other questions?
I don't. Thank you so much. These have been really good questions to listen to.
Great. Arzu, did you have any other questions?
I just wanted to bring up one more point that they mentioned, that our speakers mentioned, about interjecting your personality. And I really like that, because I do see, especially when they first start out, I feel like some people try to be like some other people and they're not themselves. And that comes through, especially to the people who know them. So that is, I think that's a great point.
Yeah, I think it's really important to, you've got to embrace, who you are and your style, whatever that is. And I think, people can see that really quickly with Samita and I, the way that we present. It's not going to be like, the next person, and that's fine. That's the way that we like to present. And so that way we're being really genuine with ourselves and with our audience. And I think people can really pick up on that. And that's how you get the audience to buy in. And when the audience buys in, it helps you feel more confident about what you're doing, that they're listening to you and that they're engaged. So absolutely, it's that age-old advice, right, of just be yourself. That I think that applies here as well.
Right. It's just like doing a jury trial. The jurors can tell if you're being yourself and being genuine, or you're trying to be something else. So I think that's really important as well. I've really enjoyed when listening to the presentations, when I feel like the person is exactly who that person in real life is. So thank you so much for that.
Thank you.
Yeah, before we let you go, I have one last question, and this is sort of a broader question. So the purpose of doing this collaboration with the Minority Council was to also encourage more people of color, attorneys of color, to participate in doing these presentations. And so as you two are women of color and you have your own firm, I wanted to ask both of you, having done these public sort of presentations, has that helped you in terms of your branding? And as minority attorneys, as women of color in a field that oftentimes overlooks minorities, how has it helped you? Has it helped you at all? And if it has, in what way? And why you would encourage other attorneys of color to follow suit?
I would say, I think a couple of things. I think first, as you begin to present, you start realizing that you do know more than you think you do about what you're talking about. And so I think that helps just across, right, all levels. And then I think it just helps build legitimacy and credibility for you, for your brand, and for your practice, because people can see that you're out there talking about these things. And when people see that, they go, oh, well, that person must know what they're talking about. Look at all these places that are asking them to speak. So I think, one presentation begets another. And so once you start doing them, I think you'll kind of see that that's what happens. And so I absolutely think it's an important part of anyone's practice. But you're right, especially for women attorneys, especially for women of color attorneys, it's a really, really great way for you to establish yourself as an expert in your practice area. So I do think it's incredibly important to do.
Thank you. Samita, do you have any feedback?
No, I totally agree with what Zakia is saying. I think you just have to jump off as she said before, jump off the cliff and start doing them. No one's gonna, it'll be some time before somebody actually comes to you and asks you to present, and that comes with doing a lot of presentations and having a history of that. But in the beginning, you need to go out and say, hey, would you like me to, I see you have this regular thing. Would you, is it possible for me to speak? This is what I want to speak on. You have to go out and ask for those opportunities. Open mouths get fed. So you have to go and find out where those are that are best for your particular practice area and just ask.
You know what? That's a really good point. In our first couple of years, every networking meeting we had, we told them that we like to do presentations and public speaking. And so if there was ever a need for them to reach out to us, and that is how we got, I think, all of our presentations for the first couple of years. And then that kind of, led into other things. But yeah, you have to bring it up. You've got to advocate for yourself. And every time you're meeting with somebody, they should walk away knowing what you do and whether or not you want to present or educate people about it. They should absolutely leave knowing that.
And thank you so much for doing that, because in doing that, you've been paving the way for other women attorneys of color to be able to do the same thing. Because a lot of times we don't see each other. I mean, we don't see ourselves as the kind of people we've always seen give these presentations. By seeing more women of color, women attorneys of color doing these presentations, the rest of us feel more comfortable doing the same thing. So thank you so much for that, for being the trailblazers.
Yeah, thank you. I certainly hope so. I'd love to see a stream of women of color attorneys, out there doing this too. So that'd be great.
Okay, with that, we wanted to thank you both again for taking your time for doing this, and thanks to the audience and my colleagues. We appreciate it. Again, these videos should be available on the CMCP and CEB's platform. If you have any other questions, you can reach out to us. The materials have the contact information for the speakers and the staff. And thank you again, and we hope to see you for our upcoming webinars in the coming weeks. Thanks, everyone. Have a great day.
Thanks to all of you. Thank you.
Bye.